May it please the court, my name is Alan Wax. I'm here on behalf of Acosta, the appellant in this matter. We ask for the reversal of the trial court's summary judgment because Acosta sought indemnity in this coverage action for losses that were in connection with claims that did not arise out of either the turnover suit or the wrongful acts asserted within the turnover suit or related to those wrongful acts asserted within the turnover suit. I would ask for 6 minutes to be reserved.
Okay, I'm trying to remind you, but you have the clock in front of you.
Yes, Your Honor. The starting point, because we're here on a claim for indemnity, the starting point has to be what was the loss. This is not a case that came before this court where the coverage action was pending at the same time as the underlying litigation. The underlying litigation got litigated through its conclusion before the coverage action was filed. So what we now have is a situation where we have the settlement, the policies at issue define loss as the settlement or the judgment. In this case, it's the settlement. And the case law tells us we look at the facts as they exist at the time of that settlement, the record evidence below, and we determine what the loss is from that. And then when we turn to these particular exclusions, we then say, do we have a loss in connection with a claim that falls within the prior pending litigation exclusions? Here, the loss that got litigated arose out of only about 3 of the 27 counts in the underlying litigation that were being asserted against Acosta. The discovery, both in the
but don't all these claims relate to removal of material from, marketing, whatever they're called, offices? No,
Your Honor, and that is the important point, because in the underlying litigation, the loss that got discovered, that is to say, what the parties were litigating in that underlying litigation for those 2-year span, that claim dealt with this conspiracy claim, this notion that Acosta and the officers and directors of marketing specialists pre-petition, which by definition would be prior to May 28 of 2001, conspired while marketing specialist was in the zone of insolvency to harm the marketing specialist by obtaining the channel division. Then the conspiracy claim and the breach of fiduciary obligations claim and the violation of the automatic stay claim go on to say, in that 2-week period between May 28, 2001 and June 7, 2001, Acosta and Advantage and Crossmark, its other 2 national competitors, then began to hire these former employees of marketing specialists and began to service the manufacturers who were going on service because marketing specialists no longer had the employees to do it. And by doing that and engaging in that conduct, they committed wrongful acts that inevitably caused marketing specialists to lose these divisions of their business. In Acosta's case, it was the channel division was the big claim.
Wasn't it necessary for Acosta to use marketing specialists' physical property, such as laptops, to obtain his intangible property?
There are allegations of that in the 2nd and 4th amended complaint. The record evidence of what the claim was that the creditors' trust was litigating, and including Mr. Alexander's testimony in this case, reflects no, that wasn't. Their claim against Acosta was the simple hiring of the employees, the former employees, and the simple servicing of those manufacturers who could not be serviced by marketing specialists. That wound up moving the relationships and the goodwill from marketing specialists over to Acosta, Advantage, and Crossmark as well, who were alleged to be joint tortfeasors on those claims. As a result of that, they claim that Acosta destroyed marketing specialists' goodwill. And so that particular claim did not depend on anything having to do with, and there's evidence in this record before the trial court, that particular claim did not have anything to do with any tangible personal property or possession of tangible personal property or even access to it.
Okay, you use the term evidence, and I want to know what I can consider, or what we can consider what the trial court can consider. You know, my understanding of the law of coverage is that in determining the duty to defend a particular lawsuit, which is broader than the duty to indemnify, you're only allowed to look at the pleadings in the two cases. Could the trial court here go beyond the pleadings, and can we go beyond the pleadings to determine the coverage issue?
Yes, sir. And I would say that in this particular case, we get to do that for a few reasons. First, the first reason is the policy itself. If you look at the exclusions, and specifically the National Union exclusions found in the record at 92-93, and the Arrowwood exclusion is found in the record at 138. And if we look at those exclusions, we're not dealing with a traditional commercial general liability policy where there's a duty of defense. Those exclusions and these policies are indemnity policies. They don't have a duty of defense. In fact, the National Union policy says there is no duty of defense. The exclusion itself, though, doesn't appear in a vacuum. It says the indemnitor shall not have to pay for any loss in connection with the claim. And so then when you look at the definition of loss, we then see that loss refers to a settlement or judgment. And then when you go into the case law of what is the loss is going to be defined in the indemnity context as the facts as they existed in the judgment or as they existed at the time of settlement. So my first point would be, before you can even go down this road to say, does this exclusion apply or not, we have to know what is the loss. And you can only determine that from the record evidence. Moreover, if we look at Arrowwood's policy language,
don't we first have to look at what is a claim?
I think we have to look at what is a claim as well.
So how did the policy define claim?
The policy, one of the policies doesn't define claim. The National Union one does define claim. And in that definition of claim, there's a series of alternatives, one of which is the written demand for monetary relief. And the Faraday case addressing this exact issue before this court out of the Supreme Court of Delaware said that multiple, where you have one lawsuit does not necessarily equal one claim where you have multiple.
But that is not the only, that's only part A of the definition of claim in the policy, isn't that correct? Doesn't the policy go on to say, or a civil, criminal, administrative, regulatory, or arbitration proceeding for monetary or non-monetary relief, which is commenced by service of a complaint or a similar pleading? Why doesn't that portion of the definition of claim apply here?
Well, because, again, two reasons. One, if you read that portion to mean that once you have multiple claims, that suddenly, if it gets joined into a lawsuit, it becomes one claim, you create an absurd interpretation where now the presence of uncovered claims in the same suit as potentially covered claims would result in a forfeiture of coverage for everything. And Florida jurisprudence, as it deals with similar concepts in insurance law, has consistently, and the one that comes to mind most immediately is duty of defense. We say, if we have covered and uncovered claims joined in the same lawsuit, you have to defend the whole thing because there might be indemnity for the covered claim, and the mere presence of uncovered claims within that lawsuit doesn't
Well, in that regard,
yes, sir.
The Second District noted in Ware Carroll Porter versus American International Specialty lines that the duty to indemnify cannot exist if there is no duty to defend. Do you disagree with this statement?
I think there's cases that go differently than that, and we've cited a few of them in the brief, but as a general proposition, I don't disagree with the statement, and I don't think that does any injustice to this case. Had there been a duty of defense, again, we have to back up because there was no duty of defense in this case. But had there been a duty of defense, it's our contention that the allegations, as we've set forth and shown to the court in our briefs, in both the reply brief to Erwood's brief and in our initial brief, where you can find the allegations in the Second and Fourth Amendment complaint that would state a claim that would be within the scope of coverage and outside of this exclusion.
Bottom line here, though, can't you look at both lawsuits and say they were both related of an overall scheme to take over marketing specialists, business, business?
No, sir. Certainly, the underlying litigation, you can say that. You can't say that with respect to the turnover suit. Again, the turnover suit, and we addressed this and the law on this in the reply brief, more specifically to Erwood, because the law on what a turnover suit is that it is a unique creature of bankruptcy law that requires a ministerial determination. That is to say, the only wrongful act within a turnover suit is the mere possession of property that belongs without dispute to the estate. So there didn't need to be anything wrongful, and there wasn't anything inherently wrongful with any of Acosta's conduct alleged in that turnover suit with respect to hiring the marketing specialist, former employees, or servicing their customers, or any contact Acosta had with marketing specialists, officers, and directors. But when we get to the underlying litigation, the very stuff that at the time marketing specialist was asking us to do at the time of the turnover suit, that stuff became what the underlying lawsuit's claims were all about and what got litigated in that case.
So what it comes down to, if I understand your argument, is that because Acosta was not accused of a wrongful act in the turnover suit, it could not be a previously made claim. I mean, doesn't that what it comes down to? Because you're talking about basically the same kind of facts. You're talking about trying to, get their business. I mean, I think that's really not in dispute. But it seems like the core of your argument is that what previously happened was not a wrongful act on the part of Acosta.
While ultimately that the trial judge in the turnover suit found that there was no wrongful act on the part of Acosta, that's not my argument, so I don't want to...
Well, help me here.
Yeah, I will.
If he had found that there was a wrongful act on the part of Acosta, would you be standing there?
Yes.
And help me with that.
I will, Your Honor. In the turnover suit, the wrongful act was possession of property belonging to the estate without regard to how it came into your possession. That is what a turnover suit is. And any claims that were connected with a loss in our lawsuit that had to do with possession of tangible personal property, we would acknowledge we would have a problem on that on the basis of this exclusion. Because the purpose of the exclusion, you don't want to insure the house on the ground.
But there's some of that tangible personal property involved, laptops, computers. In terms of the information that was gleaned from the computers, would that be relevant to the second lawsuit?
Jerry Alexander, when he testified, he was the author of the second lawsuit, said he wasn't asserting claims based on laptops or their journals. But even putting that aside for a minute, the record evidence of what was being litigated in the underlying lawsuit was clear that it had nothing to do with possession or gaining information. It was the relationships. There was this group of employees who had relationships with the manufacturers. And by Acosta hiring these former employees and beginning to service these manufacturers in the days following marketing specialist bankruptcy, even though it was done with the debtor's request, the creditor's trust said, by doing that, we got the goodwill. We got the relationships.
Would you agree that in some circumstances, an exclusion may be applicable based on the pleadings alone?
Yes, sir. I would agree with that. Okay, I would just briefly like to get back to the loss issue, just to remind the court, we talked about this in our brief, and this is at supplemental record 293 to 302, there is when National Union initially declined coverage, in this case, National Union declined coverage as to Acosta, but they accepted coverage as to one of the directors and officers. And when they did that, and this was based on the Second Amendment complaint, which had 27 counts in it, National Union said, we reserve National Union's right to allocate defense costs and indemnity, if any, for this claim between covered and non-covered parties and claims. Clearly, they were recognizing that one lawsuit, like this Second Amendment complaint, could have multiple claims, and there would need to be an apportionment and allocation between the covered and uncovered. I'll reserve the rest of my time. Thank you.
Good morning. May it please the Court, my name is Anthony Russo, and I represent Arrowwood Indemnity Company. I have 10 of the 20 minutes for the appellees.
Again, I'll try to remind you that you're open to response.
Yes, Mr. Jeffrey Cohen represents National Union. He'll take the final 10 minutes. There is one critical point that I wish to make to the Court in these 10 minutes, aside from answering the Court's questions, and that is to explain that both the complaint for turnover and injunctive relief that was filed by marketing specialists against Acosta in the bankruptcy petition, as well as the complaint for damages, the Fourth Amendment complaint filed in the federal district court, both arose out of the same facts or the same related acts, as those terms are defined in this policy. And arising out of is important because it's found in exclusion 4E that we rely on. And the term arising out of is also the centerpiece of the Florida Supreme Court's decision in Taurus from 2005. And that's central to the decision of the trial court and our position. Arising out of, as the Supreme Court said on the final page, is to be given a broad interpretation. And it includes...
You know what's interesting to me, bankruptcy is in a world of its own. I mean, for bankruptcy litigation, turnover suits, those kinds of things.
Yes.
It really doesn't seem to me that we're really talking about the same kind of wrongful act. Does that make a difference?
What act, wrongful act, is a term of art defined in the policy. So it's whether we think it's wrongful or the judge found it's wrongful is irrelevant. What matters is what is alleged, and does it match what is the definition in the policy. And if you look at Record 92, I believe it is, in the policy, the National Union policy, wrongful act as to the company is defined as any act of the company. It's a little bit different when it's referring to the specific directors and officers. And
How's it referring to the first suit as the remedy suit? Do you agree with that?
I've seen it described that way. I've seen people use that. I don't know how lawsuits are described as friendly. What Acosta was accused of doing was looting. Well, that word was not used in the turnover suit. Taking these the paper files, the hard copy files, and the computers, and interfering with the business of marketing specialists to the extent that a federal bankruptcy judge was asked to stop Acosta from going forward before marketing specialists' chances of reorganization were totally destroyed. And that's an allegation of a wrongful act. And whether or not the trial judge, the bankruptcy judge, said it was wrongful or not, whether that was even an issue, doesn't matter because it was an allegation of a wrongful act at a time before our policies were issued. And perhaps it would help if I backed up a bit and explained that our policies, our clients' policies, defend these companies or provide coverage for liability for wrongful acts, which is defined in the term, that arise in the policy period, where the insured has notice within the policy period. Because it's a claims-made policy, if the insured had notice of those wrongful acts at a time before the policy issue, there's no coverage. It's excluded. So what we look for here, the analysis is where the wrongful acts that were alleged in the Fourth Amendment complaint the same wrongful acts or related wrongful acts defined in the policy that were alleged in the turnover
It may
complaint.
not matter, but if your policy had been in effect at the time of bankruptcy, would you have had coverage?
I would think we would, but they were not. There was a buyback period. The policies, I think, were sold and issued in 2002, but there was something called a continuity date. So a prior date of coverage was established back to November 1, 2001.
The turnover suit then would not have been considered prior litigation.
If it had occurred after the continuity date, that's correct.
Do you agree that suit-to-suit analysis requires the conclusion that repetition of a single fact from the turnover suit results in lack of coverage for the entire underlying suit?
The suit-to-suit analysis, I'm not sure about the answer to the question. I think that Your Honor, the way I would approach it is the analysis is dictated by the terms of the policy, which require that we look to see if there's any prior or pending litigation or proceeding alleged the same or related wrongful act that is currently alleged in the action for which the insured seeks coverage. So you compare the two complaints.
If, I'm trying to figure out how to frame this question.
I understand the complexity of it.
If we buy off that there was no wrongful act in the turnover to the bankruptcy, where would that put us?
We are in the same place because it doesn't matter what the final adjudication was, if there was one, because it's what was alleged. Was there a wrongful act alleged? The liability policy insurance that we all have through our homeowners and our auto policies doesn't provide coverage if we're alleged to be if we're adjudicated to be not guilty. If we get sued, something is alleged against us, our liability coverage kicks in. And it doesn't matter what the final adjudication is. We have coverage for an allegation of negligence against us. Same here. Coverage exists for an allegation. I think that's the correct way to approach the adjudication issue. And that also touches on the question you asked. Can we look outside the record, or it's outside the complaints? And the answer is no, because the insurance policies insure against liability. Liability is alleged in a complaint or in a proceeding. Liability does not arise out of what somebody says in a deposition. Liability does not arise out of a letter that somebody wrote. Well, liability is a claim. And that's why we stick to an analysis of the wrongful acts that are alleged in the complaint for turnover, in the complaint that came later in the district court.
For counsel, for purposes of summary judgment in this case, if the exclusion clause was unambiguous for purposes of granting a motion for summary judgment, why did the insurers not figure out that it applied until 4 years after Acosta was joined in the underlying suit?
I can't answer why it was not alleged. I can say, Judge, that there is no coverage by estoppel. There is no waiver. You can't waive, an insurance company does not waive itself into coverage by failing to assert a defense at a specific time. I don't know what the factual background of the investigation was or what the allegations of what we knew when, but it was asserted in sufficient time for the insured to do the discovery they needed to do and make the pleadings. I'm sorry, I cannot answer that question any more directly than that, but I know it does not make a difference to the outcome here.
One quick question. Assuming that the complaint in the underlying action in this case, had a number of counts and causes of action therein, if 25 of those, or however many there were, had no relation to the factual scenario in the turnover suit.
Yes.
and your opponents suffered a loss on those other claims.
Yes.
Although all of these things were in one lawsuit, would they then be entitled to coverage on those other claims or loss on those claims that had nothing to do with the factual scenario in the turnover suit?
I would say no. There is no duty to indemnify non-covered allegations. So if there was damages, whether or not there would have been a duty to pay for the defense of those allegations is another question. But there would be no duty to indemnify any damages, judgments entered against the insured for those non-covered claims.
Even though they didn't arise out of facts or a factual scenario that was the subject of a prior lawsuit.
If they were covered, if they were like first arose for the first time, yes, there would be a responsibility to. But I hear you describing covered claims.
Well, and what I'm describing, perhaps not as clearly as I could, is a situation in which you have one cause of action that would arguably not be covered or would be excluded, and then others that are unrelated to any other factual scenario that had come up in a claim before. I guess your opponents are suggesting that the sort of look at the complaint and it's all or nothing is the position that you're taking, and they're suggesting that that is unfair or unreasonable.
The position we're taking comes from the policy language arising out of. If the claims that were made in the turnover suit arose out of a nucleus of facts that are the same nucleus of facts out of which the Fourth Amendment complaint arose out of, and that's the position I'm taking. I see.
You're talking about, but I'm going to give you your other counsel on that. But as I understand it, if there wasn't, I understand it was more still response. If there were counts in that new complaint that did not arise out of the turnover suit, and they were covered under the contract, you would have a duty.
If they arose for the first time during the claims period, say it was totally unrelated directors and officers claim, if there would be a duty, it would trigger the coverage of the policy. If they rose for the first time in the policy period, but the point is, as a matter of law, it did not. Of course, that's our position. Thank you, Your Honor.
Okay. Clerk, would you have a minute and a half, and then add a minute and a half to the other side as well? You have 10 minutes.
Thank you, Your Honor. May it please the Court, I'm Jeff Cohen from Carlton Fields, representing National Union. The turnover suit, what we call the turnover suit, was actually a lawsuit to enjoin bad conduct that Acosta was accused of committing. What we've been calling the underlying suit was a lawsuit to recover damages for that very same conduct. That is why the underlying suit arises out of the turnover suit. Now, we've talked, and there's been some questions about the turnover suit. And, lawyers like to shorten things, and we like to pick names for something, and somehow we picked the name turnover suit. And that has played into the argument that, well, this is just give us back our computers and our boxes of files. But that is really not what the turnover suit is about. The turnover suit is about protecting the assets of the bankrupt estate and protecting them from interference by Acosta, including taking some of the boxes of files and the laptops. Let me tell you what it says, and I want to read you just a few lines from the turnover suit to make this very clear. The property of marketing specialist is threatened with irreparable injury by the actions of Acosta. You asked if it alleged wrongful acts. I suggest that that's an allegation of wrongful act. Once an Acosta...
Well, we argue with you.
Huh?
We argue with you.
Yes, sir, please.
For claimship.
Okay.
Just because somebody does something that's irreparably injure someone else, does that mean that the act that the person is taking is wrongful?
Yes, sir, I would say that that does.
Okay, let's play this one out.
All right.
If I'm a bank, and I foreclose on your property, you getting thrown out of your home would be an irreparable injury to you, right? But it would not necessarily be a wrongful act on the part of the bank.
It would not be a wrongful act, I agree.
Okay, well, I think let you get away with that.
Okay, well,
In regards to a wrongful act, the bankruptcy court determined that Acosta did not engage in wrongdoing. Now, does this foreclose a conclusion that were wrongful acts at issue in the turnover suit?
no, sir. It's an interesting that you asked that question because there, in fact, were wrongful acts, and I'm going to come back to your question, Judge Wolf, but I want to answer Judge Lewis's question first. In the underlying suit, the plaintiff moved for summary judgment, and Acosta defended that summary judgment by just the very same comment that you made, Your Honor. They came to court and they said, wait a second. You can't enter judgment against us. This all happened in the bankruptcy court. The judge in the bankruptcy court found no wrongdoing, and specifically, they allege in their summary judgment response, rather than appeal Judge Sharp's findings, the plaintiffs now seek to have this district court relitigate and urge that the district court revise the finding of its previous 105 cause of action pertaining to alleged state violations. So what you heard from Acosta in the underlying suit is 180 degrees different than what you're hearing here. What they said in the underlying suit is, wait a minute, this was all a matter that was taken up in the turnover suit, and we didn't do anything wrong, and therefore we should be entitled to be out of this case. So I hope that answers your question. There's an allegation, and this is determined by the allegations. If they were innocent or found to be innocent by the bankruptcy judge, and there's some question about whether they were actually found to be innocent, what the judge says, they certainly got the property of marketing specialists. They got it because of this interim agreement that the parties entered into. And the fact that they have this and got all of this stuff is not the fault of Acosta, it's the fault of the former marketing specialists, employees and executives that went over and went to work for Acosta and took their records. But whether it was wrongful or it wasn't wrongful is not the issue. The issue is whether it's the same allegation in both cases. And Acosta has already said it is the same allegation in both cases. And they say we were found innocent, therefore you can't sue us. So that's just different than what you're hearing here today. I want to go back to the turnover suit because you pushed me on wrongful acts. Absent the requested relief, Acosta's interference with the operations of marketing specialists will seriously undermine the debtor's reorganization or liquidation efforts. All right. This court must act pursuant to Section 105 to preserve and protect its jurisdiction and the assets of the debtor. The property rights, this is on paragraph 19, the property rights involved are unique and irreplaceable, and the consequences of any precipitous action on the behalf of Acosta would be impossible to measure accurately in monetary terms. Then they asked for an injunction against Acosta from taking any action to seize, possess, hold, control, assign, transfer, sell, or in any way whatsoever affect the interests of marketing specialists in and to its property, including but not limited to its equipment, computers, files, records, mails, and checks. So the contention that this is only about physical property is not accurate. This injunction says you cannot interfere with their property rights. And their property rights are both tangible and intangible. If you take somebody's computer and you give it back, which is what happened here, but you take all of the information on that computer and you use it for your own benefit improperly, that is a wrongful act. And that's what happened here, and that is in fact what is alleged in the underlying suit. It's the same thing. The underlying suit, they say, after this interim agreement, and the trial judge specifically found that all of these harms focused around the interim agreement. The interim agreement was done 4 days after the bankruptcy petition. They got together and they cooked up an arrangement whereby the marketing specialist people already started moving over to Acosta and taking their computers and taking these records. And there's an allegation in the underlying suit that between June 1 and June 11, in 11 days, Acosta recovered $11 million of income that would have gone to marketing specialists but for this conduct.
The bottom line, what you're saying, paraphrase, you're saying it's inappropriate conduct under the Bankruptcy Act, therefore it equates to a wrongful act.
Yes, sir, it is. Those were some of the specific allegations that were made in the underlying suit. Protect the bankruptcy estate, and they violated the automatic stay. That was alleged too. So yes, Your Honor, that is what makes it a wrongful act. And it is certainly all related. The exclusion that we have here is there's two ways that the exclusion applies. One is whether the two prongs, does the claim, and we have this contention, by the way, about what a claim is, and I want to come to that.
Regarding that contention.
Go ahead, please, after you. Okay, I'll go. Doesn't that dispute create enough of a factual dispute that the trial court should not have granted summary judgment at this point?
I'm a little bit lost by the question, Your Honor, and maybe you can help me. When you say the dispute, what are you referring to?
About what a claim is and what claims are covered and excluded and what claims the Acosta suffered a loss on. Doesn't that all create sufficient factual dispute to have precluded summary judgment at this point?
No. The reason for that is the interpretation of an insurance policy is an issue of law. Coverage is determined, in cases say Florida has a bright line rule. It's determined from the allegations of the complaint. The definition of what a claim is, I suggest to you, is in the policy. A claim is defined in two different ways. It's a written demand, or, as it happened in this case, a request for a tolling of the statute of limitations, or a legal proceeding. That is what a claim is, a legal proceeding. The contention that each count of the legal proceeding is a claim violates the terms of the policy. The policy goes on to say that a claim can allege related wrongful acts, even though there are different parties, even though they've got different legal names, as long as there's a common nucleus of facts. And I have one question. Yes, sir. And I got one more answer to you.
Acosta, in support of this claim-to-claim analysis, which they are alleged required in this case, rely on the case of AT&T versus Ferry.
Yes, sir.
Didn't the Verde Court reject the same interpretation of claim that you are advancing here, based on a similar policy definition?
It definitely rejected the position I'm advancing. Yes. I don't believe the policies are the same, and it's the law of Delaware that was applied here. There is a Florida case that was decided by the 11th Circuit called Wendt, which is what the judge relied on, which says as long as there's a common nucleus of facts, the prior litigation applies. But I want to go back to the question that really both asked.
I will give you 20 seconds to do that.
I'll do it in 20 seconds. This claim argument is a red herring, because if you read the underlying case, what you see is that every count alleges the allegations of every other count. And the claims that are against Acosta repeat the same allegations over and over and over again. So even if we were going to do a claim-by-claim analysis...
You didn't make it. Thank you. I was good.
Thank you.
Thank you. I'd like to try and address some of the questions that were asked of the appellees that we think we have better answers for. That being said, I'd like to start off by talking about AT&T versus Faraday. AT&T versus Faraday did not involve similar policy language. It involved identical policy language. If the court goes back and looks at that AT&T case, you're going to see it's a national union policy. It's one of the two policies being talked about. And that appellate court quotes the identical language that we're dealing with in this national union policy in this case. Further, the Wendt decision out of the 11th Circuit doesn't address this issue at all. In Wendt, what you had was two lawsuits, both of which were dealing with the sale of bad securities. Lawsuit number 1 was a class action. Lawsuit number 2 was some individual who sues for the sale of that same bad security with no explanation as to why. So presumptively, he's somebody who must have opted out of the class. It's the identical conduct. The only differential that the insured was arguing in that case was my security has a different certificate number. The 11th Circuit said that's not enough. You have to look at the wrongful acts. Further, one of you, I believe it was Judge Wolf, asked, would this turnover suit have been covered had it been tendered as a claim to some carrier in June of 2001? The answer is clearly no. Because the only issue was the possession of property. Moreover, despite the excerpts out of the turnover suit that were read, here's paragraph 17 of the turnover suit. The files, equipment, mail, and other personal property of marketing specialists of the estate is property of marketing specialists.
Whether it was covered or not,
Yes.
if in fact we find that the turnover suit did allege wrongful acts, and that there are facts, underlying facts that are basically the same, would you
I think I have to break down my answer if I can, and then let me know if I'm not being responsible. I'm genuinely trying to be. It is in fact beyond dispute that some of the allegations of that turnover suit get repeated in the underlying litigation. We don't deny that. For instance, there's a conversion count in that underlying litigation, and that conversion count, if we had paid a loss in connection with that conversion count, and that's what the evidence showed, we'd probably be out. I get that. But so that conversion count would be what appellees are now trying to suggest matches up to the count for damages that is somehow connected with the count for give us the property back. But like so many times in complex commercial litigation, I think this gets right to the heart of Judge Marstow's question. You have here a 200-page complaint. The kitchen sink is in this complaint. And as the discovery goes on, and as the parties are litigating it, some of these things fall by the wayside because somebody just sat down and wrote them one day, and that's not what the litigation became about. And that gets to the heart of your question.
Yeah, and I'm not a big fan of claims made policies. But isn't that what claims made policies are all about? I mean, you're on notice, and you got filed before, and you're alleged at one class. Even if the claims fall out, if it was alleged in the previous lawsuit, you're on notice. And
I acknowledge we were on notice that we were being accused of being in wrongful possession of property, just tangible personal property of the state. But I cannot stress enough what we actually got sued for and what we settled. The claim that we settled, and the record evidence shows that we settled, had nothing at all to do with possession of property. It wasn't even, as Your Honor was asking me on the first go-round, this sort of tortious interference claim.
Okay, well, help me again.
Okay.
If I understand what you're saying just now, that if we buy off that we can't look, and I know you're not saying this, but if we buy off that we can't look beyond the allegations of the individual complaints in each case, you're in trouble.
No, sir. We have shown, Your Honor, in our initial brief, where you can find, and as well as in our reply brief there, where we've shown you where you can find the allegations that ultimately did become the loss in this case, where you can find those allegations in the second amended complaint that have nothing at all to do with any notion that we wrongfully possessed property, that have to do with, in fact, this claim that we destroyed the goodwill.
I read the brief. Now I'm getting a little confused here, but what I heard you just say before was, because of the conversion count, if that conversion count is good, you would not be able to proceed against the insurance.
No, Your Honor, if that's what you heard, I misspoke. I apologize then, I misspoke. We don't have any potential right to recovery on any loss in connection with that claim, the conversion count. But that wasn't what the loss was here. In this particular case, the loss was we hired these employees, we serviced these manufacturers, and somehow we destroyed the goodwill. That's why you heard the suggestion that there was this notion of $11 million of damages. But the damages model that we were faced with was the $160 million damage model of the destruction of the goodwill of the channel division, and why we paid $20.5 million to settle that claim. That claim had nothing to do with property, nothing to do with us having any computer or alleged to have had a computer. So we respectfully suggest that there are questions of fact on what is the loss, what is the claim, in this case ought to be remanded for further proceedings.